My name is Harstedt, and this is Joss, and this is Crescente, and we are the conveners. So, to you, Crescente.
Thanks. Thanks everyone for coming. Welcome to the first session of the JDG. Today we're pleased to have two speakers from the house from Oxford, and one commentator also from Oxford, which is unusual. Usually we invite people from elsewhere. Well, Tarun's also related to Melbourne and also to NYU. But Tarun and Sandy will briefly talk about their paper, Theorising Areas of Law. We'll introduce it, then we will have a comment by Timothy, and then we'll open the session for questions. So, Sandy.
Well, thank you very much to the JDG crowd for inviting us, and to Timothy for commenting, and to all of you for turning out. So Sandy's done a lot of work on theorizing tort law, and I've done something on discrimination law, and we had these conversations for a long time about thinking more generally about particular jurisprudence. We got some funding to write a joint paper. We used up the funding and realized we hadn't written a joint paper. So it was just the moral pressure of making the two funders that this paper came about. So what we are offering are some general thoughts on doing particular jurisprudence. The center of gravity in jurisprudence, at least in Oxford, differs, appears to be shifting, not necessarily away from general jurisprudence, but a lot more people are working on theorizing labor law and international law. So it's good for all of us to sit down and think about how to do this. We'll start with a few comments on the nature of theorization itself, and then I will say what we take an area of law to mean, and then we will broadly taxonomize three broad approaches to theorizing particular areas of law. On theorization, we claim in the paper that a theory of a phenomenon, say X, which could be tort law, say, is an attempt to state a consistent set of true, general, and salient propositions about X. So the first theoretical agenda is truth-seeking. A theoretical claim that is untrue is simply by virtue of it being untrue, unsuccessful. Theories also must be general. So a theory of chairs, for example, that claims that chairs have four metallic legs, has simply not considered enough instances of chairs to make generally true claims about chairs. And therefore theorization necessarily entails abstraction. And this has important implications for choice of jurisdictions and theorizing about particular areas of law, which we'll return to. The third thing we say is that theoretical claims have to be salient. They have to be important. Salient for understanding, because that is the key theoretical purpose. Salient in revealing certain features of this phenomenon that we did not already know, and of course it depends on who your audience is and what the theoretical purpose is. And finally, it follows from the condition of truth that theoretical claims have to form a consistent set, because if two claims within a theory are mutually inconsistent, then one of them is likely to be untrue, and therefore the theory unsuccessful. These we call the essential virtues of theorization. We also believe that theories can have non-essential virtues, like simplicity, elegance, novelty, significance, ambition, insightfulness, and so on. The primary purpose of theorization is to gain knowledge. We do acknowledge that theories often have an impact in the real world. The history of politics and religion is a history of theories changing the world demonstrably and remarkably in many ways. And even so, we insist that the main purpose, the main point of theorization must be theoretical, to explain the phenomenon. We finally, and this is the closing remark on general comments about theorization, we say that theories should be modest about their practical application because of the feature of generality or abstraction. Theories do not provide, are not meant to provide, in all things considered, practical solution to any real-world problem. They may help in illuminating parts of a problem, but criticizing a theory on that ground, that it fails to provide a real-world solution to a practical problem, is failing to grasp the very nature of theorization itself. One could ask several types of questions, theoretical questions, and this is the structure of the second half of the paper. One set of questions are conceptual questions. Conceptual questions are questions concerning the nature of X. How is X different from, or similar to, or related to Y? So what family it belongs to? What are the things it can be confused with, but it's distinct? So remember Hart trying to distinguish rules from habits. That's a conceptual type of analysis. What are the constitutive elements of X? So not only what it belongs to, the bigger set, but also what it can be broken down into. How do these constitutive elements interrelate? Is X a member of some larger group of phenomenon? So that's a conceptual question set. The second set of theoretical questions could be empirical. What effects does X have? How do X's act? What caused or causes X? What factors influence the actions of X? And finally, the third set is normative, evaluative, or functional questions. Is X good, efficient, legitimate, desirable, beautiful, virtuous? How should X's act? How should X's be divided, distributed, amalgamated, interrelated? What is or ought to be the purpose or function of X? It should be obvious that the conceptual and normative questions largely employ philosophical tools, whereas the empirical ones need social science methods in order to do the job. The second part of the paper thinks about what is an area of law. Now, any theoretical enterprise seeking to find a common taxonomical basis for all the areas of law that the academy and legal practice divide it into is likely to end in frustration, because there are multiple bases for these distinctions. Sometimes an area of law is organized around a particular type of legal response. Take criminal law around punishment. At other times, they regulate specific relationships, so labor law, international law, or family law are examples of that. Sometimes they're about special types of things, property law. Others are based around regulation of certain categories of people. Refugee law is an example. So law subdivides itself in response to pragmatic needs, with little regard to conceptual tidiness. And legal academy, whose curriculum also passes out law in discrete, graspable chunks, sometimes follows and sometimes leads these practical subdivisions, but is rarely indifferent to them. So they can diverge, but they are in conversation with each other. That does not mean that areas of law are imaginary. They are real. They're real in the sense that they're social forms, to use a Radzian term. They're social forms, that is, forms of behavior which are widely practiced within that group, but they're also what we call an intersubjective phenomenon, in the sense that an area of law exists in a particular jurisprudence because of its shared acceptance in the consciousness of several persons, mainly in legal practice and in the academy. Not all details of their contents need to be shared, but as an intersubjective social form, they cannot exist outside of this shared consciousness. Other examples of intersubjective phenomena, things like religion, money, nations. So areas of law are similar types of things. They exist in the minds of a critical mass of people. So they're necessarily human artifacts, but unlike particular legal norms, they cannot simply be willed into existence. I cannot decide to create an area of law. They evolve more than can be. Even Parliament cannot simply legislate an area of law into existence. Practice has to adopt it. The point about the Soraya paradox here, how many people need to accept an area of law for it to be an area of law? We say there's some things which are clearly areas of law in this jurisdiction. Labor law is one, family law is another.
Wait, Karen, employment, what happened there? What labor law, then you nearly said employment law. Are those different areas?
Maybe or maybe not, right? So this is, Timothy's pushing me on the gray zone, right? One of them is an area of law, possibly both, right? And even human rights law, so I had dinner at a temple once, and this lawyer told me, why do all your students keep writing me wanting an employment, wanting a pupillage in human rights law? There's no such thing in practice, right? So academy and practice can have different views about areas of law, but they are things that we can disagree about and still accept that there's a core that is common to. So we can disagree about labels, we can disagree about contours. We can also see, so food law in US appears to be emerging as an area of law. It's not quite clear it's there yet. And we don't know of any jurisdiction that has something called Tuesday law, law regulating Tuesdays. So we are not planning to be exhaustive about all types of theorization. Some theories deal with legal building blocks, rights, intentions, causation, remedies, liabilities. We are not dealing with that. If you pick up Salmon on jurisprudence, that used to be all of jurisprudence once upon a time, and I think not any less important for that reason. The second type of theorization that we are not looking at are theories that adopt a specific ideological lens to examine the law. Critical race theory, feminist legal theory, Marxist analysis of law, law and economics, these are all examples of looking at law from a particular lens. Now, what happens when an area becomes accepted as an area of law? It has real-world consequences, which is that actors within a legal system start imposing coherence-seeking pulls on this area of law. So, as practice and the academy come to recognize them, they also simultaneously start giving this field an internal coherence. And this is, this coherence can be of three distinct types. The first is coherence as non-contradiction, which simply is the basic tenet of the rule of law, says that the law should not ask us to do the impossible. When two rules make conflicting demands on you within an area of law that is easier to spot, because practitioners and academics specialize in that field and notice contradictory rules more easily. This is not to say that this project of removing contradictions is ever over. New facts can generate new contradictions, but you're less likely to see contradictions within something that has been recognized as an area of law for a long time than between areas of law, for example. The second sense in which lawyers speak of coherence is the Aristotelian injunction to treat like cases alike and to treat unlike cases differently. In this sense, coherence demands consistency. And this is in part the rationale behind stare decisis in the common law system. So here coherence is simply a demand of rationality, that when you have similar facts, treat them similarly. And finally, the third sense in which academics and practitioners speak of coherence is in a more complex normative sense. And this is usually in appellate legal practice and academic journal articles in books. But here, given the practical genesis of any area of law, practitioners tend to assume that an area of law exists to serve some identifiable normative function. And it's this normative coherence that lends this area a sense of identity, makes it intelligible qua an area of law. Of course, there are, if you're doing particular jurisprudence, you will know that there are serious, important debates on what the normative foundations are, and people importantly disagree about these normative foundations. But most of them tend to agree that search is valuable. And once a normative foundation comes to be accepted by courts, then that itself becomes a self-fulfilling prophecy, because then judges will draw upon that normative foundation to develop the law over time. So in some ways, both theorization about areas of law and the practice in areas of law are potentially constitutive enterprise, because you're not just describing it. Even as you describe it, and even as you theorize about it, you lend more coherence to this area and create an area of law. Of course, coherence is a matter of degree, and I'll leave that point to one side because we're running out of time. Very briefly on conceptual theories, they often seek to either explain the necessary and sufficient conditions of something counting as an instance of that thing, or at least of the central case of that idea. the conceptual theories are not normative in the sense that they do not require what Julie Dixon calls direct evaluation. They do not necessarily require the theorist to make committed normative judgments, such as X is morally required or X is morally valuable. Most of you are probably familiar with the debate on the central case. A lot of that also applies to particular jurisprudence. I'll leave that to one side. And just end on the conceptual theory bit by saying that while descriptive, conceptual theorization is not the same thing as writing a textbook chapter on that area of law because of the generality claim and the abstraction claim. Right? So while textbook chapters also need to make true claims and describe an area of law, it's only a theoretical aspiration to make generalizable, abstract, and salient claims about an area of law, and that is what distinguishes it from a textbook chapter. Just a couple of words on empirical theories, and then I'll hand over to Sandy to deal with normative theories. While most conceptual and normative theories of areas of law tend to focus on almost exclusively on legal doctrine, empirical theories are more comfortable with asking a much broader range of questions. In general jurisprudence, at least one major strand of legal realism is an empirical theory. It claims that the primary causal explanation of judicial decisions is the classification of the facts by the judges belonging to certain factual patterns. So this is mostly thinking about legal realism, but in particular areas of law, you can ask questions like, are employers more likely to win labor disputes than employees? Do female judges award more generous damages in discrimination cases than male counterparts, and so on. But not all empirical inquiries are theoretical. In order to qualify as a theory, again, they need to satisfy some requirement not only of truth and salience, but also of generality. So either you have to study the entire population, or you have to study a representative sample that whose insights are translatable, extendable to the general sample. And of course, you have to defend your sampling process, and social scientists have developed quite sophisticated tools on how one could do that. Over to you, Sam.
Okay, so I'm left with normative theories. So in general, in the paper we say that normative theories explain an area of law in terms of the reasons for or against having that area of law. When we started to write this paper, one of the motivations, at least for me, was that when people talk about normative theories, often it seems to be talked about in a relatively monolithic way, and we thought that there were a number of distinctions that one could draw within normative theories which would be helpful to draw. So one distinction that we draw is between detached and committed normative theories. So a committed normative theory, if you like, is a full-blooded normative theory in the sense that it says tort law is justified because it protects rights of independence, and it doesn't qualify that assertion by saying if you accept that there are canteen rights of independence, or so it's committed in the sense that it asserts that this is morally justifiable without qualification. A committed normative theory, though, might still be conditional in one sense, in that it might say that tort law is justifiable if certain factual conditions exist. So if it doesn't have terrible over-deterrence effects in the world, but there the conditionality of the theory is in relation to the existence or non-existence of certain facts in the world, rather than whether things are genuinely valuable or not. And it might, of course, be just a pro tanto normative theory, so it might say that this gives us generally sufficient reasons for having this area of law, but they can be outweighed by other considerations. But it's asserting that it does indeed provide us with genuine pro tanto reasons. A detached normative theory is one which says that from a certain perspective, we ought to adopt this area of law. So from the perspective of efficiency, if you buy into efficiency, then you ought to have discrimination law, let's say. But the theorist, in offering this theory, what makes them a detached normative theorist is that they're not asserting that one ought to believe in efficiency. They're just saying that if you believe in efficiency, or from the perspective of efficiency, this is what you would get if you were committed to it. It would explain this area of law, it would justify this area of law from the perspective of efficiency. Another cross-cutting distinction is between ideal and non-ideal normative theories. So the ideality of a theory is a measure of the extent to which it ignores actual conditions, current actual conditions in the world. So an ideal normative theory might be one which says tort law is justifiable if distributive holdings are just. So on the supposition that background holdings are just, then we ought to have something like tort law. So it's supposing that some actual condition doesn't hold. Another cross-cutting distinction is between local and universal normative theories. So it seems to us possible to offer a normative theory of UK discrimination law or Singaporean contract law. It's simply just important to clarify whether that's what one is doing or whether one is trying to offer a normative theory of contract law in general. And one point we make in the paper is that if you are offering a normative theory of UK discrimination law, it's highly likely that if you're saying UK discrimination law is justified, that theory is going to tell you something about the general justification of discrimination law wherever you find it, insofar as by justifying this particular instance of discrimination law, you'll be justifying some of the necessary and sufficient conditions for something counting as discrimination law. So it's likely your theory is going to have some kind of something to say about the general justification of the phenomenon in question. So those are the three cross-cutting distinctions we draw amongst normative theories. We have a final concluding section in the normative theories part on something called interpretivist theories. Now, it's possible to use the term interpretivist theory to refer to a number of different things. We refer in the paper to two theorists who just describe themselves as interpretivists and who probably are representative of a group who would be described as interpretivists. And these are Alan Beaver and Charles Rickett. And essentially what we say about them is that their version of interpretivist theory is essentially a kind of normative theory. So in their words, the theorist that begins with what appears to be salient features of the case law, she then attempts to produce a theory that best explains these features. The legal theorist is primarily concerned not with the reasons individual judges may have had for reaching their decisions, but with the best explanation for those decisions. So it seems like what they're doing in trying to seek the best explanation of those decisions is just asking what would morally justify these decisions. And in doing so, they're offering essentially a normative account, and maybe we discuss various possibilities, whether it's a detached normative account or whether it's a committed normative account that they're offering. There are other types of interpretivist theory. It would be interesting to hear people's thoughts about whether we are missing some interpretivist theory that we ought to be discussing, and whether that deserves separate attention outside of the category of normative theories. There's another brand of interpretivism which is asking what are the moral upshots of certain legal institutions. So interpretivism in the sense of people like Scott Hershovitz or Nikos Stavropoulos. No one seems to be doing that, I think, in particular jurisprudence. No one's asking what the moral upshots of the social institutions that constitute tort law or contract law are. At least they're not doing it directly. It may have implications for engaging in that kind of project.
You could interpret what they're doing as doing that.
Yes, in a sense. And that's all I have to say, actually.
The final section?
That's more considering objections.
Okay. Well, briefly for those who are interested, we consider two objections. One on transparency. So should the normative underpinnings of a theory be necessarily transparent to practitioners? And we say no. It's not or any theoretical claim about an area of law we don't think is essential to its success that from the internal point of view of practitioners, the claim is transparent. And the problem of fit, we describe both the problem of underfit and overfit, whether either the theories theory cannot stand on the factual matrix. It's the facts are too little to support the theory, or the theory overreaches and whole swathes of legal facts are unaccounted for or become mistakes, and they're both problems in particular jurisprudence that a theorist has to engage with.
Well, thank you. I don't want to talk for too long. I want to make space for discussion. This is a terrifically fruitful paper, as well as, if you haven't had a chance to read it, I recommend it because it does two things. One is to very lightly and effectively put before you a lot of the thinking that has been done about theorizing about areas of law. Theorizing, what's the title? Theorizing Areas of Law. But it does some really original things that I've never seen. I just love this one statement that theoretical claims, being general, and I'll come back to that, cannot on their own provide, and are not meant to provide in all things considered practical solution to any particular problem. I think that's a brilliant insight. I'm wondering whether it's true, and I'll come back to it. I want to say a couple of things about theorizing and what Sandy and Tarun say about theorizing, and then a couple of things about areas of law, and then I'll leave it for the rest of you to discuss. To theorize is to come up with a theory. The Greeks, theory, it meant view, a view, literally and figuratively, like we use the word view in English, to reach a view. That's a fruitful metaphor in English as well. And I think it explains some of the essential features, as you might call them, about theory. Theoretical propositions must, there's a must there, must be general. By the way, you know what that means. There is no such thing as particular jurisprudence. No disrespect. It can't be done. Particular jurisprudence, you might say. Of course, that's true. It's just that particular jurisprudence has to have an aspect of generality. And I'll come back to that. So theoretical propositions must be general. Right? You can't give a theory of chairs that restricts the phenomenon so that your theory, your view, the view you take, doesn't apply to all the chairs. So it has to apply generally to the objects of study. And of course, that's why there can be both general jurisprudence and particular jurisprudence, as people say, because you could take a view about the nature of the law of tort and what the difference is, if any, between a crime and a tort, and this would be what Tarun and Sandy and many people call particular jurisprudence. But you have to generalize to come to a view about questions like that. One little quibble in the discussion of generality. Sandy and Tarun say that the unsuccessful theory of chairs that says that they have no legs fails to consider a sufficient number of uncontroversial instances of the phenomenon. And I just wonder whether you want to rethink the word uncontroversial, because that seems to me a little bit epiphenomenal. It's true there are uncontroversial instances of chairs that this unsuccessful theory doesn't apply to, but I think it doesn't matter whether they're controversial or not. And I would hate you to say, and I don't suppose you mean to say, that a successful theory must count as an instance of the subject matter of the theory, those objects which it is uncontroversial to count as instances. That is, it's just a quibble. Generality is essential. That's obviously sound. Truth. Oh, I like it. Truth, a criterion for good theories. Right? If your view is obstructed, you don't have a good view. If your theory is not true, you don't have a good theory. I'm quibbling again when I say I'm not sure. It sounds quite right to call it the main goal. It's so obviously sound and important, and I'm glad you put it right at the top that truth-seeking is essential. The theory must be true, or it's a bad theory. But is it the goal? Or is it just something that must be the case if you're to achieve your goal in coming to it? I just wonder. Okay, so truth, generality, salience. Now, here, salience, and this isn't equivalent, this is a sort of plea that you might unpack it a bit, because it seems to me that this is where so much of the action is. It seems to me that properly understood, it is the goal, and then maybe you want to unpack it a bit more. Salient in a theoretical sense. They should tell us something about X that aids our understanding of X. There, that's it. And it is elsewhere in this paper that you might say the goal is understanding. And that, by the way, is why theorizing is so extraordinarily diverse, and why this paper is so complex and fruitful, because there are so many different aspects of human understanding. Brian Simpson. I recommend Brian Simpson's posthumous book about H.L.A. Hart's book. And Brian Simpson, if you haven't heard of him, was an extraordinary legal scholar, a theorist, I think one might say, and late in his life, he wrote a book called, I think it's called On the Concept of Law, about H.L.A. Hart's famous contribution to general jurisprudence in the 60s, when Brian Simpson was teaching in Oxford. And it's kind of a complaint against the whole thing. Why would anyone do that? Why would anyone abstract in a way that takes you away from the actual phenomena? Why would anyone overgeneralize? Why would anyone think they've advanced in understanding by saying something blindingly obvious? Why wouldn't someone pay attention to the extraordinary complexity of the facts that you need to grasp to take a view as to the English law of torts, or crime, or the nature of the European Convention on Human Rights and so on. There are two sort of, and I think Brian Simpson was a great theorist, and I think H.L.A. Hart was a great theorist, and a kind of blind spot in Brian's intellectual imagination, thinking that the pursuit of trying to generalize was pointless, because I think they're both forms of understanding, and that's why theorizing is such a diverse activity. And if the goal is understanding, then it's a very extraordinarily diverse goal. But it does involve something that we might well call salience. Chairs are solids. Tarun and I'm quibbling it. Sorry. Tarun and Sandy say this is unlikely to be salient to most theoretical purposes. I think I actually disagree. The only point in the paper I disagree with. I think I disagree. I don't know what your theoretical purposes would be in coming up with a theory of chairs, right? And the theoretical purpose has to be to achieve some sort of understanding. Well, and maybe the problem here is just that chairs are, it's kind of obvious, you don't need to theorize about chairs. If you did, I think the solidity would be not just an essential fact, but I don't know why you say it would be unlikely to be salient to the theoretical purposes. I don't yet know what they are, and you go on to say that unearthling theorizing for the benefit of curious Martians might well include in the theory, in the view that they offer as in an explanatory fashion. Of course, explanation is the correlative of understanding, and it's understanding that the Martian needs, and you're going to offer it to them a view, a theory, and the solidity is so well salient in the sense of crucial to the purpose of building a chair, or having a chair, keeping a chair. And the Martian had better understand the difference between the evanescent chair and the solid chair, or the gaseous chair or the chair made of tissue paper and the chair made of wood or metal. So I don't know, salience is where it's at, and salience has to be, as I think you imply, relevant to the purposes. And so this strikes me as the crux of the theorizing part of the paper. And when you go on to mention sort of additional virtues, I think they're quite striking. Simplicity, elegance, novelty, significance, ambition, and insightfulness. Well, especially insightfulness, but all of those, it seems to me that they're not just sort of sideline virtues where, you know, you're buying a chair and it would be rather good if you can get it through the door so that you don't have to take the window off its hinges to get in. That's a virtue in a chair, but it's kind of collateral, because really what you want from a chair is what you would have explained to the Martian in the theory of chairs. These virtues strike me as rather essential, or as achieving values that are a matter of the purpose. Insightfulness, you might say, maybe is the purpose. Elegance, simplicity, significance strike me as kind of crucial. And maybe novelty. Novelty is a sort of criterion of success for theories, you might say. Or am I just too much used to working in universities where people try to say something new? I don't know. A brilliant, you know, you wouldn't publish a brilliant theory of criminal law that has no novelty to it. Maybe that's just a phenomenon of an industry rather than theorizing itself. Those are the things I wanted to say about theory. I just want to add something about the forms, conceptual, empirical, and normative. Conceptual, I kind of want here conceptual questions. What is the nature of X? Now, is that a conceptual question? I think of conceptual questions as how something is conceived or is to be conceived. And they're obviously related to questions of the nature of X. What I found myself recently, out of my comfort zone, finding I had to try to say something about the difference between a crime and a tort. Is that a conceptual question? Well, you might say, yes, of course, it's a question of the difference between the concept of a crime and the concept of a tort. Or you might say, no, when doing your conceptualizing and conceiving of things as crimes or torts, can be done well or done poorly, and of course there may be a community that doesn't conceive of anything as a crime, and all the wrongs are treated by the system as we treat private wrongs in the English system. They don't have the concept of crime. That of course could happen. But I'm just wondering about, and I don't want to. What's the term for what I'm looking for? Metaphysics. You know, that's you know, kind of went through a bad. Metaphysics got a bad press, and then you get people in the philosophy industry trying to stand up for metaphysics. I don't really care about the name, but aren't in the theorizing, aren't you concerned about crime, and that's and the nature of crime? Now that is so interlocked with the conceptual question of what is conceived of as crime. But I just wonder whether there's another form of theory that is neither conceptual nor strictly speaking, normative. Empirical, it strikes, of course, empirical theory, that's fair enough, because you can take an empirical view, but it strikes me that the purposes are so different. There's a lovely point, I found it, where Sandy and Tarun say, not all empirical inquiries, right, as to what facts are the case. Not all empirical inquiries about law are theoretical. In order to qualify as a theory, they need to satisfy not only the requirements of truth and salience, but also of generality. For example, a claim about the propensity of lawyers to win labor suits in the labor law court in West Delhi alone is unlikely to satisfy this criterion. It's too particular. And suppose you came up with a true, well-grounded claim that in the West Delhi labor law court, the lawyer for the employee always wins. Suppose that's the truth. And you can predict. See, I'll tell you what's going to happen. And sure enough, you're right, the judge holds in favor of the employee. A regularity as to what happens in the world. empirical. Now, I think it's arbitrary for you to say it's not theoretical. It's my theory about, it's quite a particular matter. You're going to lose the case. That's my theory. My explanation for the causation. Right? Now, and of course, empirical claims of that kind as to what causes things to happen is what's going to happen, predictions as to what's going to happen, can be extraordinarily general, or that particular, or even more particular. If you get in front of Judge Jones, you're going to lose. If you get in front of Judge so-and-so, you're going to win. Now, interesting thing about empirical claims, I think it's arbitrary to impose your criteria of generality on them. And then they are theoretical in a quite dramatically different sense from the what you call conceptual and normative. Because normative, I agree with you, it becomes theoretical when there's some generality to the normative. But empirical claims, why demand of them before you will call it? And it's because of the difference between empirical assertions and assertions as to the nature of some phenomena or as to what ought to be the case. Now, areas of law. They exist in the mind, and they are or are not arbitrary. Although often lacking a fully coherent conceptual basis that can be used to taxonomize them, these overlapping areas of law are not arbitrary, nor are they imaginary. They're intersubjective. The law of tort is the thing. It's a thing, I think they're saying, but it's a thing that is intersubjective in the sense that its existence depends on its shared acceptance, and Tarunabh spoke about that just now. Later on, they say, their demarcation may be conceptually arbitrary. But they go on to say that the acceptance of a new area, food law is their example, or how about sports law? It's already a thing, maybe, entertainment law. These matters depend on acceptance by practitioners, academics, and that's a complex set of phenomena. But their demarcation may be conceptually arbitrary. I wonder if you simply mean what you were saying about vagueness, that there's no sharp boundary, or whether you are saying it's arbitrary to discriminate between contract and tort, or between tort and crime. I just wondered how arbitrary these phenomena are, this intersubjective phenomenon of, and you might say this is conceptual, of conceiving of something as tort or as contract, as contractor, as quasi-contractors, crime or as tort. Now, I want to show you some areas of law. Do you know what, first, this is the table, part of the table of contents of Blackstone's commentaries. Could you pass those around? I tried Bracton, a brilliant compendium of the laws of England in the 1200s, and you can find the table of contents online, and it would have been many pages because Bracton takes his or their theoretical starting point as the forms of action and process in the judicial institution, and that makes the table of contents very long. And I think there's all sorts of theoretical insight in Bracton, but it doesn't offer a theoretical view of the law. Blackstone did. Now, and the other thing you might want to do if you're interested in this, what counts as an area of law, you might try the table of contents of Justinian's Institutes, which you can find on the law faculty's WebLearn site under the first year undergraduate course on Roman law. Now, what you've got, if you can see this thing, is the 4 books of Blackstone's commentaries: the rights of persons, the rights of things, private wrongs and public wrongs. And then you've got number 1, the rights of persons, broken down into this prodigious array, nicely ordered by Blackstone's imagination, into areas of law. Now, I want to make a couple of points about this. first of all, there's so much here that's contingent and the result of an accident. I think that what generates an area of law in the sense that Sandy and Tarun think about it as what somebody would say is an area, whether they say food law is an area. So much of it depends on phenomena of the legal industry in the broadest sense, both in practice, as they point out, and in academics too. And I think a lot of what we think of as areas of law depends on the needs of universities to package things into courses, and of course on the publishing industry over centuries. And the needs of Bracton to write this long compendium in a broken up fashion, and the need of anyone who writes a book to write it in a broken up fashion or to make it manageable for the reader, and of course the writers of journal articles and so on. It all and then the great texts or treatises in the 19th century did a lot to create what we think of as areas of law today, and we kind of take them for granted. So, and a lot of that is accidental, and some of this is accidental. There may be no distinction between the military and the maritime in one of Blackstone's areas of law. The rights of persons who are laity, who are in a state military or maritime. There may be no military in it, or there may be no maritime, maybe in a landlocked country. So a lot of it is contingent on the particularities of the community and its history and so on. And some of this, I think, is kind of, with respect, a bit silly, because he puts the rights of persons as a category within which you get the rights of natural persons, and they may be, as you go down, they may be magistrates for parent and child. And he ends up putting what you and I think of as administrative law and much of constitutional law into the rights of persons. I don't think it's the rights of persons, the law of magistrates. Not in the same sense that the law of children is a matter of the rights of persons. So, you can complain about the way he's accounted for what's going on here. But you see the effort he made, which isn't just to list what we always put in chapters, but to give a set of chapters of rationale. And what I'm proposing is that it's possible to do that with some sense. And there's so much of this that belongs so much in an account of the areas of law that it reveals what I think is an inherent, necessary connection between particular jurisprudence and general jurisprudence. And general jurisprudence needs this because there are certain particular forms of control of what goes on in a political community that you need if you're to have the head category law. I mean, look at, even before he gets to books 1, 2, 3, and 4. The countries subject to those laws. You need, there's an area of law, the law of jurisdiction. Not in the sense of the power of a judicial institution, but in the sense of a territory, of that to which the law of England pertains. And then when you get into rights of persons, rights of things, private wrongs and public wrongs, I think maybe you need public wrongs if you're going to have a legal system. It's hard to imagine a human community where you need a legal system and you got there and you've got a legal system going, but you don't need a law of public wrongs, etc. And of course, some of the stuff that he puts under rights of persons is essential to the structure and systematic nature. And here's a proposition of general jurisprudence for you. Law is reflexive. It needs to control itself, and then that implies a set of areas of particular jurisprudence because you need particular forms of reflexive self-control of the law by the law. And we could go on. And I haven't even got into the rights of things. I think he means, other people know Blackstone better than I do. I think he means property law rights to things. I don't know why he calls it rights of things. Don't you need some sort of property law property? And then you can't do a complete job of general jurisprudence without you either doing the job of accounting for, in the conceptual mode, the nature of property, to explain what it is that you've got when you've got law, I think. I think you need property in crime and doctrine of jurisdiction, legal doctrine of jurisdiction, and the particular areas of law that make law systematic. And doubtless you could go on. You wouldn't get as far as the need for an area of law that's called rights of persons who are in the laity, in the maritime division of the laity. That's not essential. You didn't even mention that in your general jurisprudence. But you've got to do a lot of this particular jurisprudence, and a lot of it exists in the minds of people because they're engaged in the practice of law. And I wonder whether you disagree about that, or whether you'd agree that you need to do particular jurisprudence, certain aspects of it, in order to do general jurisprudence. I'll stop there. There are other things that I'd like to ask you about, but I've talked.
Thanks, Lee. Would you like to give a response to this topic?
I just want to say one
Yeah, sure.
very brief thing. So Timothy, that was extremely helpful. Thank you, and all your comments are just taken on board. I'm not even going to respond to most of them. On the final one on this Blackstone's table of contents is extremely interesting. Just on this, I think there's a difference between. So of course, one could attempt to systematize existing areas of laws within a conceptually tidy framework, right? And that seems to be what's going on. That may or may not be possible, and I wouldn't certainly fight with that. But what is not a given is that this form of systematization would be a thing in a particular jurisprudence in the real world, right? So can you organize them? So in some ways, this is meta thinking, right? So going behind particular jurisprudence and putting all of them in a tidy structure. And that it is definitely a very good exercise, and perhaps the bridge between general and particular jurisprudence, as you point out. But it need not be an intersubjective phenomenon in itself.
Sorry, what's the it that need not be?
This meta organization of
Right.
different areas of law
Yeah.
in a conceptually tidy framework.
Yeah. So, okay, good. So this was Blackstone's product of his mind. It may have novelty, that one of the virtues of theorizing, and it may be insightful and contribute to understanding, even if nobody had ever thought of that.
And just on this point as well, so we do accept, of course, that certain legal norms can be connected to each other in various logical ways, or certain norms can be justified by other norms in a sense. You could say those norms are in an area in a different sense. That certain norms which are all justified by, say, consent,
Right.
are an area of law, and that's true independently of what anyone thinks or anything
Good.
like that. So that's just a different sense of area of law than the one that we're tracking.
So there are many ways of cutting this legal pie, and some of them are coherent, some are less coherent, and it's one way in which the practice does it.
Perfect. Questions?
I'd get